As you know, today, David and William will speak to us, and then Rhoda and Neil. Then we'll break for an hour. Oh yes, we'll break for an hour, and then Thomas will come back and present part 2 of his talk. Members who wish to come to the business meeting following Thomas's talk have a separate Zoom invitation that they can use. So let me say a little bit about what SAFS has been up to last year before introducing David and William and beginning the sessions. The Society for Academic Freedom and Scholarship is a society of mainly Canadian academics who support academic freedom in research, the free and open dissemination of research, academic freedom in teaching, academic freedom in learning, academic freedom in service at Canadian universities and universities throughout the world. We support freedom of expression on campus, the merit principle in university decisions, that is the principle that academic decisions be made on academic grounds alone, at least until academic grounds run out. We support due process and natural justice in university procedures of discipline or sanction. We are keen, above all, to secure the conditions for academic excellence in universities and to promote academic excellence. We publish 3 newsletters a year. We sponsor events on SAFS themes, and we write letters to university people when we think that something has gone wrong. SAFS is having an active 2021. Though we haven't had as many events this year as we have had in the past, certainly because of COVID-19 restrictions. Sadly, because of those restrictions, we've lost much of the public reach we used to have. Few people other than those on our mailing lists find out what we're up to. Nonetheless, we have had some events on Zoom criticizing diversity, inclusion, and equity initiatives. Dorian Abbott from the University of Chicago talked to us, and David Kwan responded. Universities and Open Inquiry, exploring the difficulties. That was a panel discussion with Mark Hecht and Kirsten and me, Francis, and Paul Viminitz moderated that discussion. Academic Mobbing, the Whys and Wherefores, with Rebecca Tuval, Paul Viminitz, Ken Westhughes, Francis Whittleson. And most recently, How to Survive the Academic Pogrom Without Sacrificing Too Much Academic Freedom. Bruce Pardy spoke to us. Now, Bruce and Lisa Bildy will speak to us again at the evening of 7 June on preferential and restricted hiring, what Canadian law says about the 2 of them. Zoom invitations to that event will go out next week. Part of the mission of SAFS is to bring SAFS themes to the attention of academics and to the attention of the general public. We've enjoyed some success this year. I would like us to enjoy even more success bringing SAFS themes to the public next year. I'm happy that many SAFS members are writing opinion pieces and getting them published in the news media, in the mainstream media occasionally, but on blogs and other places. And I encourage more of that. SAFS has sent 37 letters to university administrators to date this year. These are letters to university administrators and others. 3/4 of them concern preferential or restricted hiring or other uses of non-academic criteria in academic decisions. The use of non-academic criteria in academic decisions, especially in hiring, has mushroomed this year. And so this explains why we've written so many letters. Other letters have concerned universities imposing penalties on professors who say the wrong thing, either to students or publicly. One disturbing trend is the use of university discipline to keep professors and others from speaking their minds or engaging in critical discussion. And we heard of Francis's case. Now, discipline has always been misused this way, so that's not new. What's new is that it seems to be happening more often, more quickly, and with more severe consequences. Unfortunately, disciplinary procedures are often confidential. Universities don't release information about them, and people brought onto the carpet often don't talk about it. So the extent of this problem is unknown. I'd like to research that and find out more. As I'm sure you know, last October, SAFS was honored to receive the 2020 George Jonas Freedom Award from the Justice Center for Constitutional Freedoms. And I'll show you the nice plaque. Whoops, see if I can get it there. The nice plaque that we were given. Very, very pleased to have been honored with the George Jonas Freedom Award. Okay, our first session today features David Haskell and William McNally. David is an associate professor at Wilfrid Laurier Brantford who works in sociology of religion and communications studies. William is a professor of finance at Wilfrid Laurier in Waterloo, whose academic work covers such areas as insider trading, stock repurchases, and market microstructure. David and William will speak on Ontario universities and what the Chicago Principles legislation has and has not done for them. Thank you. So, David and William.
Can you guys hear me? I'm using a relatively new headset. Thanks.
Sorry, everyone. My internet just cut out, so I had to quickly run to the basement. So I'm just going to refigure where I'm going to speak from.
Well, you've got a minute. I'll do my intro, David.
Okay, that's great, Will.
I'm going to share my screen. I've got a slide deck to go with this, so you're not going to see our beautiful faces, I guess, after this point until the Q&A. But just before I do that, this talk very much builds off of what Mark was just saying about this trend towards discipline. So that's kind of a sub-theme. We were asked to talk about the effect that Doug Ford has made on free speech on campus. And so that's the broad focus of our talk, but we're going to get into this issue of discipline. You'll remember that when the Ford government came in, they campaigned on a promise to bring free speech back to universities. And so what we're going to do is assess how well they've done. And what we'll do now is I'm going to turn it over to David, and we're just going to kind of tag team it through this presentation.
Perfect.
So
Thanks,
over
Will.
to you, David.
Now, you may wonder why Will and I are fit to assess this situation. And using the terminology of the courtroom, because we are professors at Wilfrid Laurier, a top contender for the title of Canada's most politically correct university, we qualify as expert witnesses of university wokeness. In the words of most of our colleagues, no one can challenge our lived experience. And to prove our bona fides, let's look at the last 5 years or so of our lived experience. In 2015, our university rejected a gift of 22 bronze statues of prime ministers because they embodied white supremacy and would harm racialized students. Then in 2016, with the support of diversity office staff, a Laurier student mob vandalized a pro-life club's authorized event. Later, the student council punished the Laurier pro-life club for causing harm. Again, in 2016, a high-profile female Toronto lawyer slated to speak about women in the law had her talk canceled by activist faculty and their student minions. They said that she made the campus unsafe. Now, why? Because in the course of her professional duties, this female lawyer had represented a man that the activists didn't like. Then in late 2016, there was this atomic bomb of wokeness at Laurier, the Lindsay Shepherd incident. And the Lindsay Shepherd controversy showed that some of our professors were using threats to demand ideological conformity of their students. And it also showed that staff at the Diversity and Equity Office were willing to misquote laws to help those on the far left in the faculty bully students. It showed also that upper administration, either through cowardliness or through complicity with the ideas of the mob, well, they refused to speak out in favor of free expression. So Will and I publicly joined Lindsay in her fight, as did 2 or 3 other professors out of Laurier's 550 full-time faculty. Also, nobody wants to sit with us at the faculty holiday party. But in the end, what we saw with Lindsay was that an independent investigator exonerated Lindsay of any wrong. And he also showed that the faculty and staff had used threats and falsehoods to force their ideology. So you would think that after all of this wokeness, and then this incredible public embarrassment, that the Lindsay Shepherd controversy brought on that things would have started to get better at Laurier. Well, they really didn't. Upper administration at Laurier did launch, in the wake of the Lindsay Shepherd scandal, a free expression task force. And its mandate was to set out the rules surrounding speech on campus. And I was appointed to that task force. Of about a dozen profs, I was the only faculty member to openly support the maximum free expression that the law would allow. But in the end, I resigned when it became clear that university administration was publicly promoting free expression, that was their public face, while planning to take it away through a back door, a security fee policy. Now I'm going to turn it over to Will, and he's going to fill you in on the sudden appearance of Laurier's security fee policy.
So the security fee policy has its connection to Lindsay Shepherd because she created something called the Laurier Society for Open Inquiry, or LSOI. And its goal was to invite controversial speakers to speak on campus. Their third event, as part of their quote unquote unpopular speaker series, featured a talk by Faith Goldy. Just to note, Goldy was only 29 years old at the time and had made a name for herself as a politically incorrect critic of immigration. I booked the room because LSOI needed a faculty sponsor, and the process just involved completing a simple web form. On the night of the event, we discovered a large protest set up outside trying to disrupt the event. And you could see a picture on the shared screen. No Nazis at Laurier. Laurier facilitates white supremacy. They went Nazi very quickly on this. And they invited some Toronto cell of Antifa. So while LSOI was accused of making the campus unsafe, it invited violent masked protesters. The LSOI event was very well attended, including many journalists, and within 30 seconds of my opening remarks, the fire alarm sounded and the event was over. Ethan Jackson, a Laurier student activist and co-organizer of the protest, was quoted in the KW record saying, "I'm glad somebody was able to pull the alarm. Giving somebody who is a known white supremacist that kind of platform is in no way academic freedom. It is in no way freedom of expression." That's a perfect summary of the authoritarian anti-speech ethos so common on campus today, and a true reflection of the dominant ethos at Laurier.
Has anybody else lost Will?
Hey, am I back?
You're
Yes.
back now, Will.
Am I back?
You are back now.
Yeah, we can hear you.
Hello?
You're back.
We can hear you now, Will.
You're back, but you're not moving.
Now he's frozen.
You're frozen. You're still frozen.
You're back, but frozen.
Someone pulled the fire alarm on him.
And we have Phil's screen now somehow.
If people are having trouble with the,
There we go.
if people are having trouble with bandwidth, one suggestion is to not have your video on and just share the screen.
Yeah, I'll do that. Can you guys hear me now?
I can hear you, Will.
Okay.
I'm gonna stop my
I'll
video too, just to make sure we have clarity, because you've got your slides up.
And
Okay,
would it help if we all muted as well?
I should think so, yeah.
Okay.
Okay, so can you guys hear me?
Can hear, yep.
Okay, so just to continue, the next event was Francis Whittleson. This time when I went to book the room, the whole policy and process had changed, and now there was a security planning meeting. On May 2nd, a week before the Whittleson event, the university announced a new security fee policy. And it read in part that recent requests for room bookings to accommodate controversial speakers have raised questions around the university's policy for covering additional costs, and henceforth all additional costs will be charged to the sponsor. Note the term controversial. That qualification is made by a speaker's opponents. This policy gives opponents a carte blanche heckler's veto. On the same day, El Soy received a security bill for $5,400, and incredibly, given the short notice, Shepherd was able to crowdfund the fee and the event went ahead. But look how much security we got. You could see the metal scaffolding in front of the Bricker building. You could see rent-a-cops all over the place. Here's a picture over my beautiful wife's head. Some of the rent-a-cops. There were, in fact, 8 or 10 Waterloo Regional Police around the corner out of sight. Here's a picture of Howard and Francis and Lindsay facing down the protesters. And you can see that it's mostly Marxists. And this put Francis into a very difficult position. As a Marxist herself, she didn't know whether to give her talk or join the protesters. Eventually, it was futile to talk to a mob, and Lindsay gave up. Now, part of the reason that the opposition was so sparse was that President McClatchy directed the Office of Indigenous Initiatives to hold a pipe ceremony in the gym at
You've dropped out, Will.
Hello, can anybody hear me?
Yep, but we can't hear Will.
Okay, thank you.
Yep, that I know it's difficult to know on which end the technological difficulty is. We can't hear you, Will.
I think it must be on Will's end.
I think it is.
Will just
Yeah,
dropped off.
Yeah, it's
Okay.
clearly a problem with his internet, maybe.
All right. Well, if it's all right, I'll just continue on, so we're not sitting.
That would be great, David.
Okay. So I'm going to put my video back on, so at least you have something to look at until his slides come back. There we go. So to summarize what Will was saying is that the security fee was now put in place, and it was just another in a series of woke, or what you might call politically correct or intolerant activities that our university was happy to employ. So Will and I have provided this extensive catalog of censorship on our campus to demonstrate why we were so ecstatic when the progressive conservatives under Doug Ford won a majority in 2018. Because as you've seen, the woke cancer is deep in the bones of Wilfrid Laurier University. And we needed Doug and his government to bring in a heavy dose of anti-woke radiation. In the run-up to the election, the details were sparse, but the progressive conservatives campaigned on a promise to bring free expression back to Ontario universities. And by summer of 2018, they'd revealed the guidelines of that policy. Each university would have to create a free speech code for students and faculty to follow. The code had to be modeled on the free speech rules governing the University of Chicago. And key to those rules was the idea that you're not allowed to censor ideas or speakers simply because you disagree with them. And the government also said that Ontario universities had to file annual reports on free speech activities on their campus. Those universities that didn't adhere to the minimum requirements would face the possibility of government withholding some of their funding. So as I say, Will and I were extremely hopeful when it came to Doug. From his reputation as a pugnacious political outsider, we saw Ford as the bull in the china shop that wasn't afraid to break a few teacups. But others looked at Doug Ford and they also saw a bull, another type of bull. One such skeptic was free expression advocate and Queen's University law professor, Bruce Pardy. In fact, Professor Pardy was so convinced that Ford's policy would come to nothing, he sketched out his argument right here at the annual meeting of SAFS 2 years ago. As a keynote speaker in 2019, here's what our own Professor Pardy said. The free expression policy of the progressive conservatives will fail because rather than impose a single authoritative free expression policy on all universities, the Ford government allowed each university to craft their own free expression guidelines. As such, most guidelines contained weasel words that allowed censorship if that censorship was for the purpose of keeping students safe or free from harm. Second, Bruce noted that Doug Ford's policy really had no process by which offending universities that were actively censoring ideas, could be forced to mend their ways. There was a vague threat of funding being removed, but the process to get to that point was so hazy to be virtually non-existent. As Bruce put it, there is no right without a remedy. That is, you can have a rule, but if you can't enforce the rule, it's worthless. He deemed that free expression policies would be worthless on those grounds. So now at this point in our presentation, we need to pause and take stock. We told you that the title of this talk is, Did Doug Ford Make a Difference? And under that title, we said as expert witnesses, we would assess if under Ford, free expression is returning to Ontario universities. Well, the truth is, we could have given a different title to this presentation. And that other title would have saved us a lot of time and summed up the situation nicely. We could have called our presentation, Bruce Pardy Was Right. In fact, for the remainder of this talk, we'll simply be providing examples to show why Bruce Pardy was right. However, to save us all from depression, we'll finish on a hopeful note with some possible solutions for the future. But back to the examples to show why Bruce was right. Will, you can take it away if you're back online.
I've switched to a different network, so we'll see how this goes. So I want to tell you about our appeal to the Ombudsman. You'll recall that the Laurier administration brought in this new policy, the security fee policy, just as it was getting ready to rubber stamp its official free speech policy. And the appearance of the policy also coincided with Lindsay Shepard's Free Speech Club testing the limits of free expression on campus. As I said, it was clear to David and me that the security fee was just a backdoor way for administration to censor and cancel any speaker that didn't spout their preferred ideological platitudes. Remember, according to the policy, it was upper administration who got to decide if a speaker was quote unquote controversial, and thus if a sponsoring group was required to have to pay a security fee. Because the fee was clearly just a backdoor form of censorship, we were sure that it contravened the Ford government's requirement that all Ontario universities must guarantee free speech on campus. We believed that if we could make the people in Doug Ford's government aware of what was going on at Laurier, we could get the security fee policy trashed or at least amended so that it didn't target heterodox opinions. So we looked into the process as to how we could bring it to the government's attention. We discovered that individuals wishing to make complaints about free speech were required to first follow the usual internal process, but that unresolved complaints would be referred to the Ombudsman. So we made our first submission to the Ombudsman, and I've got a little timeline here, in November of 2018. Then we waited 6 months to be told that the case was suspended. The staff said that we'd not been official enough in our earlier complaints to the university, so they instructed us to resubmit the complaint internally at Laurier again. So we filed our attempt internally. 6 months later, the university replied to our internal complaint with this terse statement. The university has decided not to suspend the security fee policy pending review. A scan of other academic institution policies found that charging security fees for events is not an uncommon practice. Note the justification. Very weak. It's not on principles. It's just because other schools do it too. This kind of standard policy herding that we see. So we resubmitted the complaint to the Ombudsman. But meanwhile, outside of Ontario, the other provinces were taking some real action. The JCCF case, which was on behalf of Pro-Life, an anti-abortion student group against U of A, had an Alberta Court of Appeal decision. And that decision had two components to it. First, it said that U of A's security fee was deemed, quote, unreasonable and unlawful, close quote. And two, it found that the charter rights and particularly free speech applied on universities and applied to universities' regulation of student speech. So based on that court ruling, we were hopeful when in late January of 2020, we had a conference call with the Ombudsman's office. They had, at this point, assigned new staff to our case, and the new staff had to be briefed on the complaint and we're going to reinvestigate from scratch. And when we asked about it, the office manager refused to consider the Alberta precedent and said that it was irrelevant. So 6 months later, in now October of 2020, the Ombudsman completed their investigation, and guess what? They decided to take no action. In their letter, they reminded us of their purview, and they said that, quote, the Ombudsman does not normally investigate broader public policy decisions. Rather, the Ombudsman can address complaints about administrative issues. And administratively, they had determined that Laurier had followed its own booking and security fee policies correctly. The Ombudsman did not feel obligated or indeed capable of passing judgment on the fairness or morality of the security fee policy. Those policies were deemed broader policy decisions. And I think that decision on their part was fair. The Ombudsman's office really doesn't have the intellectual horsepower to weigh arguments for or against free speech policy. But our conclusion of this unhappy episode is that there's no effective appeal mechanism under the Ford policy. Now, of course, Bruce Party had already observed this fact, but we had to test it. I have to close with a quote from Franz Kafka. You come home one day and find all the documents you've submitted, which you've worked hard to create and which you had the best hopes for, lying on the desk. They've been sent back as they can't be carried through to the next stage in the trial. They're just worthless scraps of paper. Our 20-page appeal was, to quote Kafka, worthless scraps of paper. The Ford policy failed because, as Bruce Party explained, there was no remedy. I'll turn it over to David now.
Thanks, Will. So if Will and I held out hope that Doug Ford and his government would prove to be a dose of radiation to the cancer of wokeness on Ontario campuses, that hope was abandoned completely when the George Floyd controversy gripped the world. In response to the rioting that followed George Floyd's death at the hands of police, Doug Ford made a public assessment of the situation. He said, "Thank God we're different than the United States, and we don't have the systemic deep roots they've had for years." Now, if you missed it, Ford had denied systemic racism. His comments made him the target of hate for every social justice warrior in Ontario. They screamed that only a racist would deny that Canada and Ontario are boiling with systemic racism. Ford, who's shown now that he's more interested in being liked than standing on principle, reversed his earlier comments. On June 4th, 2020, he proclaimed, "Of course there's systemic racism in Ontario. There's systemic racism across the country. Doug Ford had publicly shown he would cave to the woke mob, and people at universities across Ontario were watching. He'd just given the green light to every activist at every university to trumpet their wildest claims of systemic racism on their campuses. It was clear Ford wouldn't stand in their way because he'd joined them. At universities across Canada, a flurry of public statements were issued declaring that systemic racism was running rampant on campuses, and Laurier was no exception. And like many other universities, upper administration at Laurier talked of implementing a host of new radical measures that would fix the overwhelming racism on our campus. There would be hiring based on skin color and ethnicity, and to guarantee inclusivity, those with the least melanin would be excluded from applying. There'd be mandatory indoctrination or diversity training for new hires. If those new hires were white, they'd be told of their toxic implicit bias. If they were non-white, they'd be told of their constant oppression that they suffered. Most worrying, however, there would be greater policing of things said on campus, including in the classroom. Laurier would make sure that no student from a racialized or marginalized group ever experienced harmful words or ideas. That was what we heard. As I mentioned, our university president issued a public statement saying that our campus was rife with systemic racism. Well, Will and I wrote a public letter challenging that claim. It's actually available on the SAFS website. And in our letter, we noted that such strong claims of racism require strong evidence. And as we pointed out, our president hadn't supplied that evidence. We also questioned our president's backing of greater restrictions on free expression. In her statement, she had quoted examples that she felt should be emulated. And in those was the suggestion that classroom content should be censored if minority students perceive the content to be oppressive or invalidating of their lived experience. Under this new approach to instruction, we noted that a professor presenting peer-reviewed studies could be charged with racist activity if the facts presented offended a student. For example, we said that a prof presenting research showing police shootings are not racially motivated is quite likely going to invalidate the lived experience of some minority student in the class. And that invalidation would be racist. Over to Will.
I want to remind everyone what question our presentation seeks to answer. We're assessing whether ideological diversity and free expression have gotten better since Doug Ford came to power. In this final portion of our presentation, you're going to see that things have gotten much, much worse. The social justice activists have realized that Doug Ford is a paper tiger, or continuing with our previous animal metaphor, he's not a bull in the china shop, he's just full of bull. Politically, there's no one willing to stand up to the neo-racist and ideological tyrants controlling much of our universities. Because the tyrants know they have free reign, their actions are fast and furious. Let me tell you about what happened after our public letter. We saw the first vestiges of a cancel mob in mid-July when the editor of the campus newspaper wrote an op-ed titled "The Untouchables: Can Tenured Professors Be Fired for Inflammatory Comments?" The article started by saying, quote, "Many students are calling on the school to reprimand professors who participate in and instigate harmful discussions around race." No points if you can guess who the unnamed professors are. Well, it was me and David. Note our key transgression. It's that we instigated a harmful discussion around race. According to the student newspaper, universities are no places for discussions. The op-ed implicitly calls on students to provide the university with the grounds to fire us. The editor's misunderstanding of the importance of academic freedom and the role of tenure in buttressing that freedom are, to quote Mark Mercer, witless and shameless. One of my favorite Mercer quotes. The irony that the editor used her freedom of speech to try and limit ours eluded her. 1 week after the op-ed, the mob took full flight on social media with the creation of accounts on both Instagram and Twitter called WLU Changes Due. The group behind this, of course, all anonymous, were a collection of WLU faculty, students, and local citizens that called on President McClatchy to, of course, fire McNally and Haskell for their, quote, racist and white supremacist ideas and values. And I got just a couple of screenshots here from their Instagram account. So 1 week after the creation of WLU Changes Due, the student newspaper, the editor again wrote another piece, this time profiling the mob, titled "Student Collective WLU Changes Due Demands Laurier Takes Action Against Racism," by which, of course, she meant that David and I be fired. Now, the big, I want to close with a big sort of policy shift. And then that's going to set up David to close out our talk by telling the story of how they're coming to cancel him. We're not exactly sure when, but at some point in the fall or winter of the last 6 months, this statement came out on the Laurier website. It's titled "The Intersection of Freedom of Expression and Equity, Diversity, and Inclusion." And one can't help but think that there's going to be a car accident at that intersection. This statement appears to be the cornerstone for the new Associate Vice President of EDI, Barrington Walker. And so it bears careful scrutiny. It's so important that it actually appears in 2 locations on the university website. In essence, what this statement does is it provides instructions for students who feel harmed by their professor's speech to formally complain. Let me show you just a few pieces because it's quite revealing and somewhat horrifying. So it starts, this is the first sentence. Wilfrid Laurier University is aware of the outrage, frustration, and sadness being expressed in response to comments by some faculty members on social media. No points if you can guess who those unnamed faculty members are. Like, just unbelievable that they would base a university policy on targeting a particular faculty members. And then the statement goes on to legitimize the harm by idea concept, which is so central. Quote, Laurier acknowledges, sorry, I want to try and read this like Benjamin Boyce would. Laurier acknowledges the harm online comments can cause. This harm must be collectively mitigated by fostering a campus environment in which all members of the Laurier community feel safe, welcome, and valued. I don't even know what this stuff means. Should students feel valued? I'll leave that for you to ponder. It goes on to state, there's a difference between personal opinions that are expressed on social media versus ideas and arguments that are expressed in the classroom. Now remember, this is written by the Diversity and Equity Office. It might have been penned by Barrington Walker himself, but there's no signature at the bottom. But really, is there a difference between what can be said online and what can be said in the classroom? I didn't know there was that difference. I thought the Charter of Rights and Freedoms applied both off and on campus. Then it goes on to say, it is fundamental to the academic environment that the university does not hinder or penalize faculty members for exercising their legal rights to free expression. Great, but you sense a big but coming. These freedoms are not unlimited, including in classrooms. Laurier students and employees can raise issues or complaints related to discrimination, harassment, or where speech or actions promote or engender violence or physical harm. The university will review and apply university policies and procedures. speech that promotes physical harm is already illegal under the criminal code, so there's really no point in even saying that. But prescribing speech that constitutes harassment is vague and subjective. Just as an example, I know of a faculty member who may or may not be on this Zoom call, who's subject to a harassment complaint in part because of questions she asked at a conference. The complainant simply didn't like the cut of her jib and filed a harassment complaint. But the clincher of this new policy comes in its final sentence. If students have experienced racism, hate, or oppression in the classroom, there are avenues at Laurier to address concerns. See below. And then below that are the names and links to all the university offices to which you could complain. But hate and oppression are subjective, especially oppression. Virtually anything can be characterized as oppressive under critical social justice theory, since oppression is its foundational assumption. What this document is doing is weaponizing the students as snitches against the faculty. Now I'm going to turn it over to David, who's going to provide some firsthand evidence of this weaponizing of students.
Thanks, Will. So Will has just been relaying how various factions at our universities, from journalists at the school newspaper to anonymous faculty colleagues to staff and upper administrators, how they've been producing what we'll call theory. And it's theory related to getting heretical professors silenced or fired. And in academia, as you know, there's always a movement from theory into practice. And I'll briefly try to recount how this theory morphed into practice in my own classroom. Those who know me know that my public profile is that of a free speech absolutist, and I'm also an ideological heretic in that I support conservative values. Well, that's put a target on my back. But I always wasn't a pariah. I don't want you to think that this is something, a character that I've embodied since the beginning of my career, because up until 2016, just before my support of free expression became more public, I had a very strong reputation for excellence in the classroom. Year after year, I'd received a letter of commendation for my teaching from my dean, and one year I was nominated for a Laurier Teaching Award. But now, in the fall of 2020, and in particular, the winter of 2021, the praise had stopped and the accusation started. It was like some mysterious force was egging my students on. Now, I have two major examples of students weaponizing complaints. Both examples come from my public speaking course that was just last semester. Public speaking, as you would imagine, is usually an in-person course, but in the winter semester and in the fall semester before it, thanks to COVID, everything was online. The course is typically one I teach every semester, and I've been at it for about 15 years. And in those 15 years, up to now, I've never had a complaint. But as I said, in the semester that just concluded, two major complaints were lodged against me. The first complaint came from a female student in my class, complaining about a grade that was the gist of the kernel that brought the complaint forward. She said that I had discriminated against her because of her ethnicity and sexual orientation. Now, because of time constraints, I'm not going to go into all the details of that case. So I'll just tell you some of the most bizarre bits. First of all, the student hijacked my online class and defamed me during that disruption of the lecture. She eventually, as I was desperately trying to figure out how to block her, she left on her own. But then she brought the official complaint of discrimination against me, and she went through the Office of Dispute Resolution. I should let you know that her hijacking of my class is against the Student Code of Conduct. And when I asked for her to be disciplined, officials at my university said that she had not transgressed that policy. But of course, the complaint against me was deemed credible to proceed. The Office of Dispute Resolution was overseeing the matter, but because it was a lie, it went nowhere. But officials at Laurier didn't want me to know that. It was only when I called out Laurier's head of dispute resolution, when I called her out on her deliberate I want to say obfuscation, but I can't say it correctly, on her deliberate beating around the bush, that she admitted that she had no evidence for the case to proceed. Now, I left that for a moment, and the thought occurred to me. I've been wrongfully accused here. And Laurier has a policy stating that students making false or vexatious claims against a professor are to be disciplined. So I asked the head of dispute resolution if she'd be acting on that policy. I was told that policy didn't apply. So nothing ever happened to that student. All right, now to the second complaint that came against me. It was while I was dealing with the false accusation of this first student that my dean alerted me that some other students from my public speaking class had raised serious concerns about the final assignment in the course. Because of the nature of those concerns, I was told that I'd be hearing from the arbiter of fairness and neutrality. Again, it was the head of Laurier's dispute resolution. When I got that email, I saw it for the serious threat that it was. The head of dispute said that the requirements of my final assignment were potentially in breach of Ontario's Human Rights Code. A professor breaching the Human Rights Code can be fired. Of course, you're wondering, Haskell, what kind of bigoted assignment did you create? So I'll give you the details. For the final assignment, students had to write and deliver a persuasive speech. The speech would use research and emotional appeals to convince an audience to accept a particular position. It was a few of the topics that the students had to choose from that were, according to the head of dispute resolution, leading to a classroom environment that was unsafe. For example, I said that students could choose to do a speech on the gender wage gap. They could argue that the gap between men and women's salaries was due to sexism and discrimination, or they could argue that other factors were the cause. I said that students could choose to do a speech on police shootings of Blacks. They could argue that such shootings were racially motivated, or they could argue that race is not a motivating factor. I said that students could choose to do a speech on trans women competing in women's sport. They could argue that it should be allowed, or they could argue it shouldn't be allowed. Now remember, students could argue either side of the issue. To best hone their skills, I did encourage them to take the side that they deemed to be the harder side to argue, but I left the choice up to them. I'm sure if the assignment had compelled students to argue for the woke side of the issue, that is the side that most aligned with the ideas promoted by diversity and equity offices across the country, then my assignment would not have drawn any attention. My assignment raised alarms because students were given the choice. They were given the chance to argue that evidence shows sexism isn't causing the wage gap. They were able to argue that research might prove race isn't a motivating factor in police shooting. Or they could argue that empirical and physiological reasons do exist for why you might not want trans women, born biological men, participating in women's sports. But choices like that will make your classroom unsafe, I was told. Allowing students to freely explore either side or all sides of an issue will cause harm. You may recall it was Nathan Rambucana, the Laurier faculty advisor and accuser of Lindsay Shepherd, who said it best on that secretly recorded audio. He said, in the classroom, some ideas simply are not up for debate. And that's what the head of dispute resolution at Laurier wanted me to believe. More than that, she wanted me to believe that if I allowed that assignment to go ahead with the topics as they were, under the Ontario Human Rights Code, I could be in for some serious consequences. She said, quote, "It is the topics and not the assignment itself that raise concerns about the possibility of complaints related to the OHRC, the Ontario Human Rights Code." Moving on, she said, "I was hoping to be proactive given the concerns that have been raised with your dean and in light of the topics that are directly referenced as part of the prohibited grounds under the OHRC. Specifically, those grounds are gender identity and race. Students who may identify with a particular race or sexual identity may feel disadvantaged or impacted by listening to or participating in certain speeches. My aim, as I'm sure is yours, is to create a positive and meaningful experience for all students while protecting individuals from disadvantage based on their lived experiences. I'm coming to the conclusion, so I'll make this short. I had had enough. In particular, I'd had enough of the bullying and the lies. In the most respectful way, I told the head of dispute resolution to go screw off. Here was my response to her Ontario human rights threats. It's the exact quote. While it's difficult to unpack, it seems that you are saying that my assignment does not infringe on any grounds protected by the Ontario Human Rights Code. What you are saying is that topics of my assignment might infringe on or impact the sensibilities of some students, which in turn would make them feel uncomfortable. I have reviewed the Ontario Human Rights Code. The Ontario Human Rights Code prohibits discrimination. It is not discrimination for students to engage in persuasive speeches about public policy issues. It is not discriminatory for students to hear empirical evidence and rational argumentation in the respectful forum of a university classroom. The Ontario Human Rights Code does not provide that students or anyone must not be exposed to ideas with which they disagree or find impactful. On the other hand, there are specific provisions within the Wilfrid Laurier Act of 1973, see Section 4, and the Faculty Collective Agreement, see Article 7, that specifically speak to my right to academic freedom. It is my firm belief that the most meaningful experience for students comes from engaging in a respectful and academic way difficult ideas that they otherwise would not have sought out. The notion that students must be protected from ideas is antithetical to the idea of a university. Changing the topics of my assignment would be a disservice to my students and a betrayal of the ideals upon which this institution was founded. But all of this raises a significant concern in my mind. This was my question to the head of dispute resolution. Is it the official position of your office that empirically verified material and philosophically sound arguments related to race or gender, if they might offend the sensibilities of one or more students, should be removed from course content as a means of protecting students you deem vulnerable? Well, I'll let you know, I never received a reply to that last question. But we all know the answer. The answer is an unequivocal yes. Yes, it is the position of all administrative officers at Laurier and likely at every university that empirically verified material and philosophically sound arguments must be removed from course content if there's a chance they will offend certain students. But remember, don't call it offense. Such pedagogy is doing them harm and making them unsafe. Will, I'll stop there and turn it over for the conclusion so we don't run out of time.
Wow.
Will has some solutions.
Zoom is so great. Yeah, I had mute on. I'm new to this Zoom thing. So concluding this is difficult. There's so much to say. One thing that we discovered in the course of preparing this is that the UK's got a very interesting piece of legislation winding its way through Parliament right now called the UK Higher Education Free Speech Bill. And so we would echo its 4 primary recommendations. One, that there be a national free speech champion. I guess that would be provincial. free speech be incorporated as a university value, so it has some, it can compete with diversity, equity, and inclusion. That universities have a duty to promote free speech, and the last one's interesting, that there be a statutory tort for breach of that duty. So individuals could actually sue if the university violated their free speech. But what we would do is amend that a little bit. We would want a province-wide speech code, and first the province put the code together or adopt a code, and not the individual universities. And this was a criticism that both party brought up 2 years ago, that letting each university do it by themselves allows for a lot of variation and a lot of weasel words. And then we think it's very important that this code not be subordinate to say codes of conduct, for example, so that university codes of conduct couldn't supersede free speech code. And then there's the issue of harassment policies. Now, some of these are workplace policies and can't be changed, but in a university context, it's very, very important that the bar for harassment be set high enough to discourage vexatious complaints, and that harassment not be based on unpopular or unfavored ideas. And we saw this in the case of Francis's complaints, that really the harassment claim was driven by differences of opinion, and that just needs to be prescribed. And then finally, it's very important that universities not be allowed to make commitments about the learning environment. And we've seen words in this presentation about a safe learning environment, or a learning environment that's hate-free or non-oppressive. These kinds of commitments by universities create grounds for complaints, and we just need to remove that completely from the arsenal of students and faculty, because right now those kinds of complaints are, as Mark Mercer was saying earlier, kind of the primary method by which people are being attacked, and this is resulting in what he was saying were university disciplinary actions. So we really feel like getting speech, free speech is sort of having primacy is critical. And I'll just stop it there, and thank you all very much.